Well, to avoid any lights flashing, I will comfortably finish within the, to reassure you, the allotted minutes well before. I was just about to come to the last authority I was going to refer to, having looked at those passages in Mr. Justice Tilgenhad's judgment, and that's the case of Rotherham, which is in...
Yes, there's Justice Cobb's judgment, yes?
Justice Cobb's judgment.
Page 695, yep.
Page 6, I'm grateful. I won't, you're obviously ahead of me. It's tab 12 in volume 1, if anyone's in the paper version. Your Lordship's aware that this was a case involving reporting restrictions in relation to a female child, G, who had been made a ward of court by the local authority, Rotherham, because of fears that she was being sexually abused by 4 males. The application made was for lifelong anonymity for G, for her family members, and the 4 males in question who were under suspicion. Now, as you'll see from paragraph 6, Times newspapers opposed the order in relation to the 4 males. And really the interest of this case, for present purposes, we say, is that Mr. Justice Cobb, we say, adopts a more realistic and, dare I say, less ivory tower appraisal of the risks faced by a...
Well, he is, of course, a family division judge.
Yes, he is. I appreciate that. But nonetheless, I mean, it is perhaps it is useful to have the family division experience being brought to bear when it comes to allegations of these kinds.
I think my lady meant it as a compliment.
Yes, I took it as such. Paragraph 39 is the passage that we cited in the skeleton argument, and it says interim injunctions. I next asked myself, what is the public interest in naming these 4 men in the press? As persons against whom injunction proceedings were once brought, interim injunctions without evidence being tested once made, but in respect of whom in the end no findings were sought, let alone made. In my judgment, there is no, or if any, negligible such public interest. As it happens, the evidence reveals that MM, one of the 4 men, had the most minimal involvement in Child G's life, having only met her briefly on the date in August when the police exercised their powers of protection. On the other hand, there is a substantial risk that, given the strength of feeling in Rotherham and elsewhere about those who engage in child sex exploitation and similar offences, they would be perceived to be perpetrators or likely perpetrators and pilloried and or targeted in their communities if they were known to have been under suspicion in this way. As the Times newspaper observes in its own leader, to which I've referred earlier, see above, quote, false rape and abuse accusations can inflict terrible damage on the reputations, prospects and health of those accused. For all the presumption of innocence, mud sticks. There is, I acknowledge, an unfortunate truth within that remark. I am satisfied that the rights enjoyed by the 4 associated males, and also to their wider families to a private and family life, would be significantly disrupted if they were to be named in the media. There is an obvious risk of reprisals, which play out at worst by overt hostility in the community, damage to themselves or their homes, or at least by subtler forms of ostracism, difficulties in personal relationships, disruption to their employment, or their prospects of employment. And we gratefully and respectfully adopt that as almost a paradigm analysis of the risks that are engaged when sexual allegations, particularly in relation to children, are involved. And then you'll see, just for the sake of completeness, paragraph 46. It's rightly uncontroversial in this case that Child G's identity should be protected now and for the future. She's an extremely vulnerable young person. It would be devastating for her to be named publicly in the press as the subject of this application and a strong deterrent to young people who may be considering coming forward to report offending of this type. Having listened carefully to the evidence of the relevant senior officers, I'm satisfied that if I named the associated males, Child G would be quickly identified in the local community in which she lives. Then that is sufficient on its own to justify the anonymity of the 4 males. However, quite apart from that factor, I've reached the firm conclusion that there is no true public interest in naming the 4 associated males, against whom, in the end, no findings have been sought or made. The Article 8 rights of the associated males would, in my judgment, significantly violated were they to be publicly exposed in the media as having been implicated to a greater or lesser degree, as we pray and aid, but not proved to be engaged in this type of offending. Their rights on these facts predominate over the Article 10 rights of the press to report their names, while not inhibiting the press from reporting more widely about this case. And that analysis, we say, could apply just as well to the facts of the present case. Any implication to a greater or even the lesser degree of simply having passed across the police's radar to the point of being arrested is an implication which is apt to cause a significant harm of the kind Mr. Justice Cobb there identifies. My Lord, I'm going to take very briefly, so as to be sure of ending in time. The final of my five categories was the growing recognition that started emerging in 2012 and 13, the growing recognition that there is an acceptance that arrest is not generally to be treated as anything other than a private act, and that the details of somebody being an arrestee or a suspect should not be released to the public. We've seen some of the references to the police material in the ERY decision that was I referred to earlier. That was the decision of Mr. Justice Nichol. So I'll just give the references. The Leveson Inquiry Report, some extracts are at page 417 following of the bundle. In particular, paragraphs 3.25, which is at page 419, which refer to the dreadful case of Mr. Jeffreys, who was wrongly pilloried in the media as a murder suspect of his tenant. And then the only paragraph 239, which is at page 427, which we saw cited earlier. And then the one passage that is perhaps worth looking at is 219, which I don't think we've looked at. That's at page 427 of the bundle. Paragraph 2.19. Oh, sorry, 421, I beg your pardon. So that's failing.
Sorry, page number?
Page number 421. And it's paragraph 2.19, 219 of Leveson. It is, however, sensible to go one stage further. It should be a matter of serious professional concern to the police that information about their activities, which should be kept confidential, is indeed confidential. The presence of the press at a high-profile arrest may indeed provide positive coverage, although unless very carefully handled, it may also give rise to difficult issues of fairness within the criminal justice process. Obviously, if for good reason a decision has been taken to brief the press about a forthcoming arrest and to allow representative attendance, the risks and the responsibilities to the target of an arrest should have been calibrated and taken into account. If there's no such authority, however, and if there is a legitimate inference that someone, whether police officer or civilian employee of the police, has leaked the information to the press generally, or a journalist specifically, I do not take the view that this is just one of those things. And that needs to be seen also in the context of 239, which is on page 427, which we've looked at before, which is the passage where Lord Justice Leveson said that it should be made abundantly clear that, save in exceptional and clearly identified circumstances, the names or identifying details of those who are arrested or suspected of a crime should not be released to the press nor the public. And as your lordships have already seen, this is a case where there was already some concern about material having been leaked by the police to the press, as recorded by Mr. Justice Tugendhat in the judgment. My Lord, the College of Policing Guidance on Relationships with the Media, that's at page 443. Starts at page 443. I'm grateful. It starts at page 436. And it's really the passage, paragraphs 351 and 352 on page 443. First, this is the College of Police's guidance. There is nothing to prevent police forces from naming an arrested person where there is a policing purpose for doing so. The media will often identify and name an arrested person without assistance from the police. Individuals themselves have the right to inform others of their arrest. Police forces must balance an individual's right to respect for a private and family life, the rights of publishers to freedom of expression, the rights of defendants to a fair trial. Decisions must be made on a case-by-case basis, but safe in clearly identified circumstances or where legal restrictions apply. The names or identifying details of those who are arrested or suspected of a crime should not be released by police forces to the press or the public. Such circumstances include a threat to life, the prevention or detection of a crime, or a matter of public interest and confidence. This approach aims to support consistency and avoid undesirable variants which can confuse press and public. So that was the rule as updated in May 2013, as you can see from the foot of the page. after the Leveson report came out in November 2012. There is then also in May 2013, and I think my citation is wrong. This is 435. Just so your lordships have the picture. And of course, this was emerging right at the time that these matters were before Judge Rook, as it happens, and then the same year, later in the year, before Mr. Justice Tugendhat. ACPO's position on naming people who've been charged. ACPO Lead on Communications Chief Constable Andrew Trotter said, we advise forces working with the CPS to name those who have been charged, and that position will not changed. When an individual has been arrested, our current guidance is not to name them, and we will only release the name for the prevention or detection of crime, or if there is a serious public interest. ACPO is working on new guidance to provide clear direction or avoid inconsistencies where some police forces confirm detail of an arrested individual. If journalists have gathered the information from other sources, this does not affect what the media themselves choose to publish. So what we have there is a clear, settled view among senior police officers that this is the way forward as of the middle of 2013, that the arrest of an individual is not something that is to be fed into the public domain and released to the public, or the media in particular. And all that comes on the back of the Leveson concerns about the sometimes unholy alliance in the past between sections of the police and sections of the media. Finally, I won't go to it, but your lordships will have seen a reference to Sir Richard Enriquez's report.
Yes.
And we've referred to paragraph 1.67. Obviously, that's his personal view that we ought to be moving back to some form of statutory, which he regards as a just cause. Obviously, we don't go that far, but it just shows the extent to which there are now real concerns emerging about the extent to which people are being stigmatised and pilloried unjustly as a result of the details of arrests being filtered to the public.
Could you just give me the page reference?
Yes, the page reference is 1241.
Yep.
That's paragraph 1.67 of the review. The actual report starts at 1198, but the passage we rely on is on 1241. Finally, can I address your lordships? Really, it's a follow-ups to three questions that were put to me in the course of the morning session. My Lady Hale put to me the question, well, does it really matter whether or not, looking at the analysis we put forward of A versus BBC, does it really matter or not whether one has to analyse the open justice principle by reference to the common law, when at the end of the day, every case falls to be determined by reference to the Article 8 versus Article 10 dichotomy? Firstly, we say the answer, it does matter. Firstly, because
there's also an Article 6 dimension.
Yes, there's an Article 6 dimension as well. But in a straightforward 8 versus 10, Article 10 versus Article 8 case, not every Article 8 versus Article 10 case will involve the open justice principle. Mainly, it doesn't arise. But when you get to the weighing up of the Article 10 factors, that is when the open justice principle can be said to come into play. And there it is that the common law does matter, we say, because there is no escaping the fact that the origins of the open justice principle are in the common law. And it's at that stage that the court needs to consider, well, where are we at so far as the common law principle of open justice is concerned? And it's at that point we say, where Lord Reed's, what we say is Lord Reed's analysis gets kicked into touch, because that's the point at which the court should be considering, well, open justice is still something where the common law, not least the common law in other jurisdictions, still has a role to play. It needs to be proactive, and the court needs to evaluate whether it needs recalibration, having regard to changes in society, new case law, and other factors.
But you're not suggesting, are you, that there is any difference in the context of open justice between the process according to whether it's dealt with at common law or the convention?
Well, ultimately, one would hope the result is the same, but of course, normally there are many judgments where even this court has said the common law marches in step with the convention, so there's never a concern. But the analysis of the open justice principle, we say, should be broad enough, not only to include, for instance, Strasbourg jurisprudence, but also other developments in other common law countries.
Certainly, but are the principles any different?
They ought not to be, I think, is the
Well,
short
in
answer.
your submission, are they or not?
I can't think of any.
I mean, your submissions don't depend on there being any difference, do they?
No, but it might be. Can I point your lordship to why we think this may be a looming difficulty? If one looks at the judgment of Lady Justice Sharp at paragraph 39, it's the danger that one has. My copy of the concern that we have is from paragraph 39 on page 112, and this was the nub of our criticisms, as you'll have discerned from the skeleton. She says she doesn't accept the approach of being tempered or modified by the decision of the Supreme Court in A. That's the S Guardian News analysis. Lord Reading, giving a judgment with which the other members of the court agreed, said at para 41 that the application of the principle of open justice may change in responses in society to the administration of justice. It can also develop. He went on to make clear at paragraph 48 that where there's a conflict between the right of the media to report legal proceedings and the rights of litigants or others under a guarantee which is itself qualified, such as Article 8, the approach which should be adopted is that described in detail by Lord Steyn in Re S and by Lord Roger in Re Guardian. But of course, those are cases that are looking at the broad sweep of Article 8 against Article 10. And it's not, of course, every case that's going, as I've said already, that's going to engage the open justice principle. The danger, as we see it for the future, and in the way Lady Justice Sharp approached it, is as she did in paragraph 38, to take the view that it's all now settled by in Re S and Guardian and news media, and that the fount of all future consideration of the principles is purely to be drawn by reference to Articles 8 and 10, and the jurisprudence feeding into Articles 8 and 10, both domestically and from Strasbourg. But that is not to say that the danger, we say, is that shuts down, potentially shuts down, consideration of common law principles that may be equally relevant when one is looking at a doctrine that emerged from the common law. And we say in relation to that doctrine, the common law still has a role to play. So one shouldn't be nervous about looking at other Commonwealth authority that may be of value to test our own common law. And the danger, as I've said, we feel, is that it is a risk that everyone becomes focused on the Strasbourg Convention channel to the unjust exclusion of consideration of common law principles. That, we say, is the danger. But to answer my Lord Sumption's question directly, we say that in practice it would be surprising, and I can certainly think of no reason why a common law analysis of the open justice principle that is alive and alert to changes in society and changes in perceptions of offences, the presumption of innocence and so forth. It's difficult to see why that should not provide an answer that is in step with the convention.
Well, can I just suggest that the convention does make quite an important difference, because the case law from pre the 1998 Act in Scott and so forth has developed in the absence of a law of privacy. And so one finds the open justice principle expressed in Scott, for example, in fairly sweeping terms. And once you have a right of privacy recognized, that has all sorts of effects, as we saw in Re S, in Campbell, in the following the Google decision in the realm of data protection and internet traffic, and equally, it's bound to have an effect on the open justice principle, where that impinges on the protection of respect for private life. And the particular relevance of the Canadian case law is because it has developed in a situation where a common law jurisdiction has adopted in the Charter a similar provision protecting private life.
Yes, I certainly accept that. There's an element of circularity, of course, from our perspective, because, of course, our judge-made common law right of privacy was in large measure fed and informed by Article 8 considerations. So the common law is not an isolationist beast. It does draw its own evolution from.
There was no common law right of privacy. Court of Appeals said so.
Well,
in a very famous case. There is a common law right of confidentiality, which has been expanded to cater for the horizontal effect of Article 8. But my Lord's point is that it's the Human Rights Convention that actually gives you
feeds
the
into
legs for the particular case that you're making, rather more than the common law does.
Yeah, and the importance of it is that if you're applying convention rights, you have to be aware of the fact that protection for all sorts of historical reasons is given a far greater importance in continental legal systems and by European judges sitting in Strasbourg than it has been in British legal culture.
Yes. Well, that's what, in one sense, that's why we say the Canadian experience is helpful, because it's another, as your Lordship's pointed out, it's another jurisdiction where there is a strong recognition of a right to privacy, in addition to the other factors we've looked at. But that's why we say, putting to one side the Article 8 Convention origins that fed our own now tort of misuse of private information, the privacy rights we recognise, it's helpful to have a common law perspective on the right to privacy in these contexts being brought to bear on the open justice principle. Yeah. So
it's when you have this necessity to balance that Mr. Justice Tugendhat's reliance on what was said in the Guardian case about, how's it put, that the law proceeds on the basis that most members of the public understand that you're innocent until proved guilty. I'd have thought it's a convention approach that enables you to mount an argument that there's an erroneous legal approach there.
Well, I'd accept that. I mean, I don't want to disavow the value of the convention to the arguments we raised below, but it's more the idea that one has effectively shut down any recourse to the common law dimension, which is what we say was the concern we had, particularly given the Court of Appeal's unwillingness to consider, in particular, for instance, the fact that Canadians seem to set much greater store by the presumption of innocence than we do, and considerations such as how realistic is it for judges still to say, well, the public generally still understand the difference between suspicion and guilt. And we say the convention arguments certainly help, but a common law perspective, as I hope the cases I've cited this morning show, can be illuminating in that regard, particularly when it's a jurisdiction that recognises a privacy right, albeit one that stems from the Canadian Charter of Rights rather than the European Convention. The second question I wanted to come back to is one put to me by Lord Clark, my Lord Clark, and that is really, well, where does as I understood it, paraphrasing it, where does the presumption of innocence end? On one view, it can be said to be a factor all the way through. Of course, one must bear in mind that the presumption of innocence features much more strongly in a case where a person is only being either interviewed by the police or has simply been arrested, because there's no criminal process that has begun. If you have a case where an individual has been charged or where the wheels of the criminal prosecution has started turning, we readily accept that other factors may, by that stage, loom larger in the context of the open justice principle. Obviously, there's a world of difference between somebody being arrested, perhaps by mistake, because of mistaken identity, having a stronger, the presumption of innocence featuring more strongly in that situation than a case where a charge has been brought, has been approved by the Crown Prosecution Service, has got past indictment, and is proceeding through the criminal prosecution system. The further it goes down the line, we readily accept the open justice considerations will change. And obviously one cannot equate the state of the presumption of innocence for somebody who's a mere arrestee and then ceases to be an arrestee with somebody who is a defendant or an accused at a trial at the Old Bailey, where, of course, he still retains the presumption of innocence. But from the perspective of open justice, the justification for allowing that consideration to override the open justice principle is correspondingly weaker. It's very difficult to imagine a situation where somebody in that situation could even hope to pray in a presumption of innocence as a basis for excluding his name from court reports of the criminal trial. But that is a world away, we say, from the situation in the present case, where really we're dealing with an individual who never got beyond being arrested for a time and was only brought into the proceedings at all by reason of a collateral Section 4.2 hearing at a time when he was still under arrest and potentially facing a charge, although that proved not to be the case. Finally, just a parting shot in relation to the fact that my Lady Hale rightly points out, we've relied on quite a number of Canadian first instance authorities, partly because, of course, the Dagenet-Mentuk principles are well settled and don't need to be revisited. But we say that it's important for the purposes of seeing and taking examples and seeing whether our law needs to be fine-tuned, to see not the original principles themselves, but to see how those principles are applied in practice on a practical level.
It did occur to me, Mr. Barker, that you said that you got short shrift in the Court of Appeal.
Yes.
When you tried to raise Canadian examples with
Yes.
them. It's just possible, maybe wrong about that had you first taken them to the Canadian principles to demonstrate that they were very similar to the principles under the European Convention, and indeed including the common law within that, they might have thought that they were more relevant to the question they had to decide.
Yes, well, I think those that were there might take a different view. I think the perception, as you've seen from the extracts from the transcript, I don't want to rake over old ground, particularly ground that gave rise to grief for me. But there was largely the perception you'll have seen of Lord Dyson that the Canadian experience was unlikely to be helpful, simply as a starting point because of their different emphasis on the presumption of innocence.
But that was why I was
Yes.
saying, if you start with, yes, freedom of publication,
Yes.
but a ban in these two criteria so defined, you're telling the court that really, why would our law be any different from theirs? And then you go on to the things that they concentrate on. But this is purely a matter of presentation.
Yes,
it doesn't
it could
matter. It won't make any difference to the way we decide.
No, I appreciate that. So far as the Canadian cases before the Court of Appeal, I think it's fair to say the Court of Appeal took the view, or so we say, that it really was, everything was settled by Ries and the Guardian case. It was Article 8 versus Article 10, and there was really nothing to be gained by going to see Canadian authorities, partly because the perception, certainly given to in the judgment and during the course of argument, was, well, there's nothing more to be said in relation to the principle itself, other than its other factors. That
Anyway, you got here,
we got
which
here
is
in the
all you
end.
needed to do.
Not all, but
No. I just say as a party...
I can see that you had to try and find some point of law of general public importance
Yes.
in order to get permission to appeal,
Yes.
and you might have focused on what you have been focusing on for that purpose. But now you're here.
And I'm grateful.
You just make the most of your case.
I'm very grateful to have been there. I mean, one is always conscious one can be shut down in the Supreme Court or in any appellate court when one is relying on first instance decisions that are merely illustrative. But as I say, these cases we have been flagging them since the Court of Appeal. My learned friends have had every opportunity, if they so wish, to come up with cases that cast a different light on the way the principles are applied in Canada. They've given it their best shot, and they've come up with some cases in Australia, America and New Zealand, and a few other Canadian cases. So it's not for want of opportunity, but we say that these cases we rely on show a very different approach in Canada that we say more reflects the realities of the situation, particularly in cases involving sex offenders and so on. I'm in danger of repeating myself, so unless I can assist at this stage, I'm deliberately not, given the time, I will come back to, if I have to the New Zealand and Australian and American cases in reply, insofar as my learned friend develops them in his own submissions. But unless I can assist, that's all I have for now.
thank you very much indeed, Mr. Barker. Thank you. Miss Reddy. Mr. Miller.
As the court will have seen from our written case, there are two parts to our submissions. First, we say this is a case about freedom of the press subject to any statutory restrictions, fully to report the proceedings at a criminal trial. It involves an application for an injunction in the High Court to prevent reporting of aspects of those criminal proceedings. We contend that the Court of Appeal correctly applied the House of Lords and Supreme Court authority bearing upon such cases in determining the appellant's appeal. So did Mr. Justice Tugendhat at first instance in deciding the original injunction application. And we say there is nothing in the decision of this court in A versus BBC which required the Court of Appeal to do anything else. In short, on the first part of our case, we say there was no error of law in the determination of the first appeal and that this appeal should be dismissed. If we need to, we will proceed to the second part of our case and say that even if there were something in A versus BBC which demanded a development of the common law, the Court of Appeal would have been wrong to develop the common law in the way urged upon you by the appellant, and so would this court. First, the reasons PNM advances in suggesting the common law should be developed in this way are misconceived. Second, the approach in the existing House of Lords Supreme Court cases is correct and is quite capable of giving protection for privacy in an appropriate case involving an arrestee or a suspect. And thirdly, if there is to be such a change in the law, it should be for Parliament to make it by legislation. Before coming to the first part of our case, I'll deal briefly, if I may, with some aspects of the facts. These are, of course, set out in detail in the first instance judgment of Mr. Justice Tugendhat at page 120, paragraphs 6 to 36. And I'll take the learned judge's summary of the facts as read, if I may.
Yes.
But it is relevant to consider briefly the respondents and how they have pursued their desire to report in this case. In the 3 years before October 2013, the Times and Mr. Norfolk, as is well known, had investigated and reported extensively on the sexual exploitation of children. The reference for that is Mr. Michael Smith's statement at page 448, paragraph 3. Moreover, the Oxford Mail had been covering Operation Bullfinch, the investigation in issue in this case, on what Mr. Colley, the deponent, describes as a constant basis since the arrests in March 2012, in which the appellant was one of the group of men arrested. And if I could just take you, please, to page 455 in the core volume in Mr. Colley's statement. The first 4 lines of paragraph 4.
Yes.
He says, local interest and concern in relation to this matter has been intense, and it is to the Oxford Mail that local people look for detailed reports about police investigations and judicial proceedings. Indeed, local newspapers are the only place where such detailed coverage is generally available, except in the highest profile cases which are covered by the nationals. The respondents' witness statements before Mr. Justice Tugendhat explain the 2 publishers' long-standing interest in contesting restrictions on court reporting. In Mr. Justice Tugendhat's judgment at paragraph 6, page 120, it is worth bearing in mind the start of the what I might call the section 4.2 saga in this case was a hearing at the Magistrates' Court. This was the hearing at which the first section 4.2 order was made, and it was a hearing in which the defendant was before the court as a party, and restrictions were placed on reporting that hearing, ordinarily an open court hearing in the Magistrates' Court. And you'll see described in Mr. Wilkinson's statement the circumstances in which that happened. He was there to report for the Oxford Mail. He was actually excluded from the hearing, and there were private parts of the hearing. But it would be wrong to think that the Section 4.2 saga has not had points at which the appellant was a party before the court, whether as somebody involved in criminal proceedings in the Magistrates' Court or as an applicant for a Section 4.2 order. As you know, Mr. Wilkinson contacted the applicant by email as the trial at the Central Criminal Court was coming to a close on the 7th of May 2013, indicating his intention to write about the arrest when he, Mr. Wilkinson, was legally able to do so. That is the email letter at page 460 in the bundle, which you were taken to this morning. And importantly, he explained in that email why he believed as a journalist that the proposed subject matter of the article he was suggesting might be written at that stage was of public interest, and of particular public interest to the readers of the Oxford Mail. He offered the appellant an opportunity to comment. Verdicts were returned at the trial on the 14th of May 2013, as the court knows. And as the court also knows, Mr. Norfolk of the Times sent the applicant a similar email to that which had been sent by Mr. Wilkinson earlier on that very day, the 14th of May. But that's at page 461, and again you were taken to that this morning. The aim was the same, to say why he considered the report relating to the arrest would be in the public interest, given the matters rehearsed in that letter, which the court has seen, and giving more detail as to the matters he intended to report than had been given by Mr. Wilkinson, those matters being a product of his investigations as a journalist. In each instance, the letter was presented as a possible argument that might be written, if legally possible, in the circumstances that pertained at that stage. And remember that there was a Section 4.2 order in place from the Crown Court at that stage. I wish, if I may, to say a word about these letters. And it's important to preface these comments by an observation that needs to be borne in mind at all stages in this case, if it's not obvious from the facts, and indeed needs to be borne in mind in relation to the future, whatever it may be. There are three areas of law that bear upon journalists in this area and restrict their ability to write. One is the law of libel, the second is the developing law of privacy, and the third, as we know, is the law of contempt, which was in play for a long period in this case and possibly could come back into play in the future. What was happening here at this stage with these letters in May 2013 was the journalists were giving an opportunity to comment and presenting the substance of the proposed article to the subject of the article in a way that in the law of libel, responsible journalists must now do in order to enhance their chances of running a Section 4 public interest speech defence under the Defamation Act 2013 if sued later on the article that they have written in defamation. That is the statutory version of the Reynolds defence, and your lordships will, and in the court, your lordships and your ladyship will remember that a component part of that has always been the opportunity to comment being given to the subject of the article and the response of the subject being built into the text of the article to give it balance. These letters also give, and they're, as I say, customarily now written to show visibly, if there are proceedings later on, how the investigative process has proceeded, an opportunity for a potential applicant who says the substance of the article will engage my Article 8 rights to apply for a privacy injunction. Where the law gets complicated for journalists, you can't get an injunction if the cause of action is defamation. You can get an injunction, prior restraint injunction, if the cause of action is privacy. So there is always the possibility that the parts of the article will now trigger that sort of injunction application. But again, in relation to privacy, it is best practice to front up, as it's called in the trade, the subject of the article so they can see what's going to be published and have the opportunity to make an application for a prior restraint order if so advised. So what was being done here was precisely that, in the slightly unusual circumstances where there was a subsisting 4-2 order. So the journalists, even if they wanted to write something about PNM, couldn't write about the parts of the court proceedings, reporting of which had been postponed under Section 4.2. It is, of course, possible for a person who has been wrongly accused of something in a way that would be defamatory if published, and receives one of these letters to comment, to respond. For example, to say there has been a terrible error here, I've been wrongly identified, in fact, this is my position. And that serves two purposes. One, that response feeds into the investigative process. The journalist may say, actually, I've got the wrong end of the stick here. There isn't a story. There isn't an allegation of the sort that I thought there could be. And it may, if the article is written, end up being included for balance in the article. That didn't happen here. A letter like this does not mean necessarily that an article will be published. Part of the responsible journalism process is to take the investigation into stages, to see if there's a response or no response, take stock of where you are later on and decide what you can and can't publish. So that was what was happening at this stage, and there is an element, I'm afraid, on our side of the case that you're damned if you do, you're damned if you don't. If you do that, you get accused, or suggestions are made in court that you're then using open justice as a Trojan horse later on when you want to try and write a different type of report. We weren't thinking like that. This was simply a fronting up letter in an investigation by the two journalists. In the event, as the judge is aware, the judge declined to lift the Section 4.2 order at the end of the trial because no decision had been taken then by the CPS as to whether to charge the appellant. His Honour Judge Rook made this clear in his ruling of the 16th of May 2013. Those possible articles referred to in the 2 May emails were not published. That was the editorial judgment. An account was taken of the fact that the Section 4.2 order was still continuing. So there would be a chunk of reporting relating to the proceedings that was still subject to a postponement. The Section 4.2 order remains in force, even though the appellant was released from police bail without charge on the 25th of July 2013. And we have Section 4.2 in the bundle in Authorities Volume 1, right at the front, tab 1, page 482. It's one of those sections we all think we know by heart, but is sometimes worth looking at just to remind ourselves of the wording of it. The provision excludes from the possibility of a strict liability contempt in relation to court reporting certain types of reporting. Section 4.1, fair and accurate report of legal proceedings held in public. Section 4.2 then allows the court to postpone reporting of any part of proceedings, or indeed the whole proceedings, or any part of the proceedings, where reporting that part of the proceedings would create a substantial risk of prejudice to the administration justice in those proceedings, or any other proceedings, these are the key words, pending or imminent. So the learned judge took the view throughout the saga of the Section 4.2 applications at the Central Criminal Court that that jurisdiction was engaged because those words were met on the facts of the case. I'll come back to this later, but it does seem a little difficult to see how that could be the case after a positive decision had been taken not to charge and to release PNM from police bail on the 25th of July.
Now, of course, at the hearing, there had, in the criminal case, there had been reference to the fact that the appellant had been arrested.
Certainly.
And so that you couldn't, under the Section 4.2 order, publicize that because it would be a publication of part of the proceedings. Is that right?
No,
but
probably.
If there had not been a reference in the proceedings to the appellant's arrest, what would the position have been? Would this order made by Judge Rook have caught that?
No, the Section 4.2 order is limited in its effect to anything that's caught by those statutory words. So if you're trying to report fairly inaccurately a part of the proceeding contemporaneously, the order postpones that. It says you can't do that at the moment, it pushes it off into the future. It's about fair and accurate contemporaneous report of the court proceedings. It doesn't preclude a journalist writing an article on the basis of their own investigations about that, but there would be other concerns about that, including strict liability, ordinary strict liability contempt or common law contempt. So there are other aspects of the law of contempt that might restrain your ability to publish that sort of thing. But Section 4.2 focuses on parts of the proceedings, submissions, evidence, exchanges with the judge, so on and so forth. And the classic case would be of voir dire in open court, any part of the proceedings in open court of voir dire, or references to by defendants accusing other people of being guilty who are about to be tried in a separate trial some months later, something like that. As you know, His Honour Judge Rook has prepared a draft ruling discharging the order, but this has not been handed down because of the High Court proceedings. As Mr. Justice Tugendhat explained. This is in the core volume at page 473, right at the end of the appendix. And I'm not going to read it to you now, as it's quite a lot to take in, but I give you the reference and refer to it because it may be helpful for the court to read it at some stage, as it sets out the position, as it were, the crystallised position at the point this case moved from the Crown Court to the High Court. It tells you the state of affairs in relation to the criminal investigation and the thinking in relation to the discontinuance of the Section 4.2 order, and indeed jurisdiction to make the Section 4.2 order. When the injunction application was intimated, emails were written to the appellant's lawyers by the publishers, as you know, explaining that they now wanted to report only certain parts of the open court proceedings at the Central Criminal Court. These would be in a report about the 4.2 proceedings in the Central Criminal Court, i.e. once the 4.2 order was lifted. And you've seen the example of the letter from TNL at page 463. The following is extremely important, and I emphasise it. These court reports would be, and this was the guarantee given in the letter, and it's the guarantee that we give here, fair and accurate court reports within the meaning of Section 14 of the Defamation Act 1996. That is also right at the beginning of Volume 1, Tab 2, and it's another one of those provisions we all think we know, but it's worth looking at. A fair and accurate report of proceedings in public before a court to which this section applies, if published contemporaneously with the proceedings, is absolutely privileged. I won't do it, but if you go back to Section 4, you'll see there is predictably statutory provision in Section 4 and similar provision in Section 14 that says if your reporting is postponed by a court order, it becomes contemporaneous at the point the order is lifted. So you can have the benefit of Section 14 at the point the Section 4.2 order is lifted, even though it may be months after the actual events at the trial that you're reporting on.
Can I ask, Ms. Miller, does that mean then that what would be published would be a report of what had actually occurred in the courtroom? Is that right?
In open court, yes.
And would that include the information about the appellant's personal circumstances, his business and so forth, which had been mentioned in the emails?
It would have to be I was going to come on to this, and I will do, how it would work. All I'm saying at the moment is it would have to be, to attract the protection of Section 14, a fair and accurate report of things said in open court in the proceedings. So what happens is, this is the minutiae of the case. This is the minutiae of the Article 10 right that's in play here. The journalists, this is a 3-month trial, the journalists sit in court throughout the whole trial and they make their notes of what's going on. And where there's a 4-2 order, you store them up and have to pick the bits out of them later on that constitute the report that you want to publish. What we don't have here, it's one of the problems with this injunction application, is in mind the whole history of the 3-month trial and every reference that was made either to the man with the same first name or to the appellant himself. But there were references, I'm going to explain in a moment, that did, in relation to that person, touch upon certain aspects of the matters in the letters.
Yes, yes. I mean, it may be difficult to discuss this without providing us with information in writing, but at some stage it would be helpful to know exactly what is the information which is an issue here, which would be published or not published depending on the outcome of these proceedings,
Well,
because
exactly.
one has to know that in order to assess the public interest in its publication on the one hand and the damage to the appellant's private life on the other hand.
Exactly. We do. Can I just come back to that in a moment and review what the evidence tells us about that and what the findings tell us about that at this stage? The point I'm making at the moment is the articles would be written to a 14.1 standard, and that means that the content would have to respect the presumption of innocence, because it would have to be a fair and accurate court report, and at all stages in the proceedings before His Honour Judge Rooke, by definition, Section 4.2 order being to protect his right to a fair trial, if he was charged and was brought to trial, emphasis was placed on his innocence. We would report that anyway, but there will be emphasis on that. How readers might react to such a court report must depend, we would say, on the form of the journalism. Thus far, we've been debating this issue in the abstract and by reference to Lord Rogers' statements in the Guardian case, which of course I will come to. But ultimately, the only thing you can cling on to in these cases, it not being possible to speculate about how the readership as a whole will react one way or the other, as a group or as a subset, is what it is proposed that will be published. Because readers will react to the content of the publication. So, to take an extreme example, if the article is strongly suggesting that the person is innocent and they've been wrongly charged, you can't reach a conclusion that everyone will jump to that conclusion, or it may be harder to do that. Depends what the words of the article are, what the article is saying, and what's being emphasised in the article. That is the one thing you cling on to in a case like that, it seems to us, if you're a judge deciding the balancing exercise. If an article, if there's grounds to believe an article is going to be sensationalist or or not a proper court report, or making accusations that are unfounded, or trying to lead the reader to the conclusion that the person is in fact guilty even though they haven't been charged, that would be a different matter. But here, the protection for the presumption of innocence is built into the type of reporting, because it was at the heart of the argument in the 4.2 case. It was one of the reasons why the 4.2 order was made, that there has to be a strong protection for the presumption of innocence. Also, this is classically journalist territory. We're going to come later on to the Jersild principles, the form of the expression, deciding what is actually in the article that is relevant and in the public interest, is a journalistic process. The journalist, Mr. Norfolk or Mr. Wilkinson, who has made the notes over that long period, will have to use journalistic techniques to decide how to achieve a Section 14.1 fair and accurate court report. But there is no basis in the appellant's case for any suggestion they will fail in that endeavour, or that they have a track record of failing in that sort of endeavour. So the court must proceed on the basis that it will explain those aspects of the trial, the reporting of which were postponed. It will explain the content of the Section 4.2 applications made on behalf of the appellant at the Crown Court, and it will explain the sequel, which is the privacy injunction proceedings in the High Court. The appellant had an opportunity to apply to the High Court for the injunction in issue before these articles were published. Again, responsible journalism giving him the opportunity to do that in the potential gap between the lapsing of the 4-2 order and the publication of the articles. And as I say, although the application failed before Mr. Justice Tugendhat, the effect of the continuing Crown Court Section 4-2 order, I should say the 4-2 order in the Magistrates' Court, the 4-2 order in the Crown Court, and the 4-2 orders that have been made in the civil proceedings as the case has gone up the appellate chain, has been to prevent the reporting of the appellant's identity, both in relation to the criminal proceedings and the High Court proceedings, and his litigation in those courts to date, 3.5 years later.
I'm afraid I hadn't understood that the holding orders made in the civil proceedings had been made under Section 4.2, but they were.
I think they were. I think there were parallel orders postponing any reporting of his identity as the litigant in the civil proceedings until the conclusion of these proceedings.
Well, do we have the order?
Page 375.
It's at the beginning of Mr. Justice Tugendhat's. Yes, it's the very first part of Mr. Justice Tugendhat's judgment. As is his practice, he deals with the open justice issues in relation to the civil proceedings before him. The order's at 471.
Thank you.
But the reasoning is in the judgment of Mr. Justice Tugendhat at page 119, starting at paragraph 1, but under the heading Postponement of Reporting, paragraph 3, you'll see he made a 4-2 in the civil proceedings as well, and that has continued all the way up to date.
Yes, I see. Thank you.
That's an ancillary, it's a pretty familiar ancillary order while the litigation is continuing. Now, the applicant says at his written case at page 64, paragraph 17.2, that he was not identified as a suspect during the trial evidence. Says the appellant at the end of 17.2 was not even identified as a, quote, suspect during the trial evidence, whether by any of the victims or any other witness. It's not altogether clear to us what that means, but C, for the factual basis on which the courts below proceeded, first of all, the Court of Appeal judgment at page 106, paragraph 10, where Lady Justice Sharp records, it is common ground that after the order was made on the 25th of January, there were references to the information. This is where it gets a bit obscure. So she's referring to the information that would be caught by the civil injunction, the various categories of identifying information relating to his status as a suspect, before the jury. There were references to it before the jury. The appellant's full name was referred to by a police officer who said that B, the young girl who had given evidence about this, had failed to pick the appellant out at a police identification procedure, and it was mentioned in the course of cross-examination, in closing speeches, and in summing up. That is, the appellant's full name was referred to in evidence in open court and mentioned in the course of cross-examination, closing speeches, and summing up by the judge. In relation to the evidence that was extracted, if I can put it that way, from the officer, it's not clear whether that was extracted from him in chief by the Crown or in cross-examination by the co-defendants. But there may have been reasons for parties to want this evidence on the record, court relating to the prosecution or the defences that they were running. We don't know the answer to that. The context is explained in the judgment of Mr. Justice Tugendhat at paragraph 9, page 120, and I think we just need to be clear about this because it confused me when I first read it. He says, one of the complainants, that's B, as she was referred to in the Court of Appeal, had referred to a man whom she alleged to have committed an offence. The name by which she referred to that man was the first name, which is the same as the claimant's first name. It's the first name which is very common, that is, it's the same as the first name of very many men. And the sequence was that position is that B hadn't yet given oral evidence, but her witness, as I understand it, her witness statement contained that evidence. The case was opened. You'll see this if you turn to page 453 in the bundle, in Mr. Wilkinson's statement. At paragraph 16.
Sorry, 453.
453, my lord, yes. Witness statement of Ben Wilkinson, paragraph 16.
Stops at
Can't
10.
be.
Stops at paragraph 10.
Oh, I'm so sorry. I'm so sorry. Paragraph 4.
Thank
Sorry,
you.
the date is 16. 16th of January.
Right, don't worry. Thank you.
Paragraph 4. It's worth reading that paragraph to get the context for the 4.2 application. What triggered it? This was the prosecution's opening of the case in open court.
Yeah.
So the 4.2 application on the 25th preceded B's evidence, but was in the light of the reporting of the opening by prosecution counsel. And that's really all I wanted to say at this stage about the facts. So I turn to the first part of our case to consider the cases at this level, House of Lords, Supreme Court, which were considered by the Court of Appeal and considered to be binding on them. The first of these was Ries, decided in 2004. In which the shape of the case, if I can put it that way, was the same as this one. In other words, it involved an application for a privacy injunction in the High Court, which, if granted, would have had the effect of restricting or preventing the media from reporting aspects of a criminal trial held in public, in another court, by definition, in the Crown Court. These were the aspects of the criminal trial which, if reported, would have identified the defendant, who was the mother of the 8-year-old boy C.S. The guardian of C.S. made the injunction application in the High Court on his behalf. C.S. was not involved in the trial, and the press had no interest in reporting his identity if it emerged in open court. And this was explained by the press at the various hearings in Ries. On the other hand, the allegation was that his older brother DS had been murdered by his mother. That was what she was being tried for. So the reporting would have been about events at the heart of the family's life. And these effects had inevitably already had a serious impact on the way CS had been and was being brought up. There was a care order.
There was a care order and there was psychiatric evidence, recent psychiatric evidence as to the impact on this surviving little boy of seeing his mother's name plastered over the tabloids for weeks on end, or however long it might have been.
All the press.
Yeah.
The application had to be made for an injunction in the High Court because the judge at the Central Criminal Court had no inherent power, for for the reasons we've explained at paragraph 14 in our written case, to order the press not to report these aspects of the criminal trial. And no statutory power exists which would have allowed the judge to do this. And that was dealt with in the judgment, in the opinion of Lord Steyne, speaking for the court in Ries at paragraph 9, which is at page 605. So the trial judge had no powers available to him in common law or under statute to prevent the press reporting the criminal trial fully. And of course, His Honour Judge Rooke was in the same position in this case in relation to prohibiting reporting of the aspects of the public hearing which were an issue before him, though he was able to use the power that we've seen in section 4.2 of the CCA to postpone reporting of them, which is rather different, because there were potentially, as we've seen, criminal proceedings against the appellant, which might have been prejudiced by contemporaneous reporting. By way of an aside from me, as it were, Ries was also a case in which the local newspaper, a local paper in Romford in that case, was heard in the High Court, as the Oxford Mail was in this case, in an attempt it could ensure it could report fully on the open court trial, though it left the national newspapers to conduct the litigation after its initial intervention in the High Court. The injunction was refused, and appeals on behalf of the child were dismissed by the Court of Appeal, by a majority, and by the House of Lords. Lord Steyne, with whom the other members of the Judicial Committee agreed, explained in the often cited passage at paragraph 17 in his opinion, which is at page 608, the report is at tab 8, a very famous passage, how the parallel analysis of the qualified Article 8 and 10 rights in play in a publication case, where the issue is about publishing private information, is to be carried out. The first point is important, obviously. The decision-making proceeds on the basis that neither right has any sort of presumptive priority. The decision depends on a close analysis of rights being claimed on the facts of that case and of the outcomes, if you like, the cases for and against each right possibly winning out. The impact of an adverse decision of the court hearing the injunction application, grant or don't grant the injunction, has to be considered. What harm will be done to the Article 8 right by any reporting or postulated reporting if no injunction is granted? What harm to the free speech rights of the press and the public will be done if the information cannot be reported because the injunction is granted? And the exercise is the same in a non-prior restraint case. You just look at the harm from the point of view of who wins in the case and what the damages might be. Back at paragraph 15 on page 607, having considered the Strasbourg cases under Article 6, Lord Steyne concluded, as per the last few lines at the bottom of the page, that there was a general and strong rule in favour of unrestricted publicity of any proceedings in a criminal trial, and that the common law had long adopted a similar approach. And if the court looks again at looks next at paragraph 18, starting at the bottom of page 608, Lord Stayne said in oral argument it was accepted by both sides that the ordinary rule is that the press, as the watchdog of the public, may report everything that takes place in a criminal court. I would add that in European jurisprudence and in domestic practice, this is a strong rule. It can only be displaced by unusual or exceptional circumstances. It is not, however, a mechanical rule. The duty of the court is to examine with care each application for a departure from the rule by reason of rights under Article 8. At paragraph 20, Lord Stayne emphasised that the creation of any new exception to the open justice principle in this area, and as we understand it, he's talking about a category exception, category of cases of the sort that would be identified in a statute, was for Parliament and not the courts. He says at 20 on page 609, given the number of existing statutory exceptions to the right to report open court criminal proceedings, it needs to be said clearly and unambiguously that the court has no power to create, by a process of analogy, except in the most compelling circumstances, further exceptions to the general principle of open justice. We respectfully agree.
Do you say that that is what would be involved in this case?
Yes.
Why is that? I mean, if the court were to allow the appeal, it would simply be making use of an existing exception for cases where the right of privacy outweighs the public interest in publication.
The question. If you overturned the outcome of the balancing exercise on the facts, that would simply be a different decision on the facts.
Yes.
But I was responding by what I thought was my learned friend's case, which is articulated under 5 headings today only for the first time when asked to do so. No criticism of him. But his 5 subclauses, of the exceptions that he wants the court to write into the common law sound to me rather like subclauses in a statutory provision. And the question is, what is he saying? Is he saying, because he's trying to have his cake and eat it, I think these should be stated as important considerations in a factual balancing exercise, or is he saying, in effect, we want you to stipulate these as if they are category type exceptions to the open justice principle? And we had understood him in his written case to be saying the latter. It's not an unimportant point. What are we really all here for as far as that submission is concerned? What is the exception he wants? And it looks to us like it is a category type exception for those prior to charge who were implicated in investigations and who are referred to in open court criminal proceedings. And I have to say, and I will say later on, that is a huge step if it is a category exception. It is a huge step because anyone who practices in the Crown Courts will know every day up and down the country, in conspiracies and other multi-handed cases, references are made for their own reasons, whether by the prosecution of the defence, to unindicted co-conspirators, to third parties who were investigated in the course of the investigation and didn't end up being charged, and arguments are raised before the jury about that. You know, and as I understand it, we're here. What about that bloke over there? What about that bloke we offstage left in this trial that we haven't heard about?
But Mr. Barker does not submit that by reason only of the belonging of this case to a particular category, that it must be regarded as an exception to the general rule. Surely he is disavowed placing it in a category or giving its inhabiting of the category that status. He says these are merely factors which should be recognised as having greater potency than hitherto acknowledged.
Right. But then as far as this case is concerned, and the decision in this case, and the appeal in this case, what is he saying? Is he saying that the balancing exercise conducted by the court below, Mr. Justice Tugendhat, was wrong in law, involved some misdirection of principle, was irrational because he failed properly to weigh those considerations? If so, he needs to put up and make his argument on the face of Mr. Justice Tugendhat's judgment. If he can't do that, this appeal can't succeed, can it? Whatever the desirability of that, and all these arguments were put, Mr. Barker's an able advocate, he put them in the first instance of the Court of Appeal. 4 judges have heard these arguments. On the facts of this case, they took a different view. That's the way the law works. And that's the way the Article 8 and Article 10 balancing exercise works. And I'm going to say later on, as we go through the cases, there is nothing in principle that precludes a judge or a court faced with those sort of arguments giving weight to those considerations, if on the facts they deserve weight, still less finding that they outweigh the open justice arguments. His problem is that in this case, Mr. Justice Tugendhat didn't reach that conclusion, and the Court of Appeal upheld his decision. And we're entitled to finality. We are a litigant in this. We're waiting to report this. We've been told we can report it. We're now on our second appeal. There's no merit in the appeal. We must say so. Whatever the desirability of his arguments that failed, repeating them in front of this court is not of any interest to us because they're dead arguments unless there was an error below. The end of paragraph 21, Lord Steyn, which is on page 610, noted that there had been a legislative choice, this bears on the facts of Ries, a legislative choice not to extend the right to restrain publicity at a criminal trial to children not concerned in the trial, like CS. i.e., Parliament hadn't made a category type exception for a child such as CS. It had long enacted Section 39 of the Children and Young Persons Act 1933, as it was then, but the beneficiary of that provision would have to be a child involved in the trial. And we, of course, and he says this is a factor that cannot be ignored in the balancing exercise. We, of course, note that exactly the same is true in this case. In relation to persons arrested but not charged in a police investigation that has given rise to a criminal trial, Parliament has not legislated for a category exception for those persons. And that must be a strong factor in our favour in this balancing exercise. And all of this was before the courts below. Ries was cited, was relied on by Mr. Justice Tugendhat and by the Court of Appeal. Lord Steyn's analysis, applying the facts of the case and carrying out the parallel analysis in the case, mandated, as he's indicated at paragraph 17, then follows paragraphs 22 to 36. Regarding the Article 8 right and the impact of any unrestricted reporting on CS's Article 8 rights, we draw the court's attention to paragraphs 24 to 27 at page 611. I won't read these out. Lord Steyn stressed the indirect impact of unrestricted reporting of the trial on CS, notwithstanding, and I emphasise this point, that the reporting would, by definition, be discussing events in his family. It would be private material in that sense. It would be published material that related to what was going on in the family, to his private and family life, because it concerned his mother and his brother and the allegations about their relationship that had given rise to the criminal trial. So in one sense, it went to the core of Article 8, what the press were going to be writing about by way of reporting on the criminal trial. But, said Lord Steyne, the impact will be indirect because he's not directly involved in the trial and his identity won't be reported upon. Here, of course, and I'm going to come on to this later by reference to Axel Springer and some of the other cases, the opposite is true. And we haven't really touched on this, but the content of what's being reported here will not be about PNM's private and family life. The allegations against him are not allegations relating to things that went on in his family or involving his family. They're entirely separate to that. They're outside the family.
Well, it won't be about his family life.
It won't be about his family, exactly.
You said private and family. I think we could debate
Well,
that.
we would say it won't be about his private life. The content of it won't be about his private life. These are allegations about offences of which he was suspected relating to others, not his children. So the content of the reporting is very, very different to Ries, in which there was no injunction granted.
Well, if one takes as a premise that he, just for the sake of argument, that he didn't in fact commit the offences, do you say that a report suggesting that he did is not, doesn't involve his private life?
No, but no. I'm going to come on to this. I keep getting pulled ahead of myself, but what I'm trying to identify is the private information, the nature of the private information. There is a distinction drawn in the cases, both in Ries and in Axel Springer, between information that impacts on your private life because it's an allegation that you committed a criminal offence and you were arrested and investigated for it but never charged, let's say an armed robbery, to take an extreme example, and information that impacts on your private life in additional ways because it is published information about what was going on within your family. So there are different types of private information. And we're moving towards a categorization on the Learned Friends case of the first example as private information. I'll come to address whether it is or when it is later on. The only point I'm making at the moment is I'm distinguishing Ries in terms of the content of the reporting because it will not be about the family.
But it's common ground in this case that Article 8 was engaged, and as I understand it, the basis on which that was common ground is not that the contents of the proposed report will be private, but that its impact on the claimant's private life will engage Article 8. Is that wrong?
As the court knows, again, I'm going to come to this later on, whether the Article 8 right is engaged depends on whether you can establish a reasonable expectation of privacy at the point where you're making...
But am I right in saying it's common ground that it is engaged?
No, the case at first instance is at paragraph 68 of Mr. Justice Tugendhat's judgment at page 135. Paragraph 68, Mr. Wolanski does not dispute that at a time before these matters were mentioned at the trial, the information the claimant had been arrested and other information was private information which engaged the claimant's Article 8 rights under Article 8. What the defendants submit is that once the information had been mentioned in open court, as it was, the claimant no longer enjoyed a reasonable expectation of privacy. But it is true to say that the case was resolved, if you read the judgments, beyond that point, on the basis of the balancing exercise.
Yeah.
Now, the question of whether the latter submission was correct, whether at the point of applying for the injunction there was no reasonable expectation of privacy because of what had come out in open court, is a rather complicated one, but it didn't attract the court or engage the court, if I can put it that way. So the court, at both instances, seemed to take it that privacy was engaged.
But once the...
But I'm not. But there is a live issue. There is a live issue there, if I can put it this way, because engagement of the privacy right is a fact-sensitive issue. If you look at Campbell and Murray versus Express newspapers, you have to look at a whole range of factors pertaining to the information at the time the right is claimed, which in this case was October 2013.
The gravamen of the appellant's complaint in his statements isn't that I was arrested behind closed doors and therefore I have an interest in maintaining the private nature of that information for that reason. It's rather that the publication of this information will have a devastating effect on my family, on my business, on my family and my business, and therefore engages Article 8.
Well, I
and indeed on my
absolutely
health
understand
also.
that. We had this in PGS, and there are aspects of the Article 8 jurisprudence that look at the impact of the reporting on the person and the family.
Well, reasonable expectation of privacy is one way of looking at what information should be protected, but it isn't the only way of looking at it. I think that's the point my Lord is making.
Yeah.
Reasonable expectation of privacy in your terms is almost circular, because if there's a provision that gives you the opportunity, the prospect of getting an injunction, then maybe you have a reasonable expectation.
Yes, well, it's certainly not the only way. I mean, by the time you get to the second stage, you look at it in a much more multifaceted way. But it is the threshold. I mean, we have to have rules for engagement of the Article 8 right, and they have to pertain to the situation at the time the right's being asserted.
What's your answer to the way Lord Reid and Lady Hale have put it to you? That it's concerned about the impact if it's widely published on his...
Oh, my answer to that is when both courts came to the balancing exercise...
But Article 8 being engaged.
Being engaged?
Engaged, yes.
No, our position is once it had come out in open court, given the status of the appellant and the way in which it came out in open court and the fact that he only applied to postpone the reporting of it during the criminal trial, meaning that it was inevitably going to be reportable at the end of the criminal trial, seems to us to make it very difficult for him to say he had a reasonable expectation of privacy by the time October 2013 came around.
But our point was that isn't the only test of what might engage Article 8. Article 8 says you have a right to respect for your private and family life. And if what is going to be done amounts to an interference with your private or family life, well then you don't necessarily have to show a reasonable expectation of privacy. There are some categories of information where that is not so obvious, as with the information that was involved in MGM and Campbell. But there are other categories of information which may indeed have an effect on one's private and family life, irrespective of whether one's sitting there saying there's a reasonable expectation of privacy.
Well,
I think my Lord was seeking to make a similar
with
point.
respect, that's not our understanding of the law.
I think
on authority.
that if we look at paragraph 14 of the Court of Appeal's judgment, they summarise the appellant's case in very much the way that Lord Reid has just summarised it, and indicated at the beginning of that paragraph that this was not disputed, which is why I'd suggested to you earlier that it was common ground. Have I misunderstood the position?
Well, it was disputed in
Did the Court of Appeal misunderstand the position? Would you like to have a look at paragraph 14 on page 107?
Could I just speak to Mr. Orlansky? Mr. Wolanski, who appeared in the Court of Appeal, says that that is a correct proposition.
What, paragraph 14 is a
Yes,
correct statement?
The dispute that was raised below was about that information emerging into the public domain in the open court proceedings.
Don't you think that Mr. Justice Tugendhat must have rejected Mr. Wolanski's rather subtle and elusive submission in paragraph 83?
I'm absolutely sure he did. But I was asked what our position was, and I'm trying to articulate. It doesn't come out very often in these cases where they end up being resolved on the balancing exercise. You don't get a lot of meat or material in the judgments about the threshold because the
I
judge.
think if you were to look at 83, you don't need to, but if you were to look at 83, you would be satisfied that Mr. Justice Tugendhat was taking an engagement of Article 8 all the way through.
Sure, absolutely. But he does record earlier on in the judgment that the position, for what it was worth, that was taken by counsel.
Yes, he does.
Was there was a distinction between the private information per se relating to the arrest and the situation as it was in October 2013 after it had emerged in open court and the Section 4.2 proceedings had taken place.
It's maybe a completely red herring, this point that Lord Reid and I are seeking to put to you. But if we think of the facts of Re S took it for granted, but it accepted that this little boy's private and family life was going to be affected by reporting of his mother's criminal trial. That's got nothing to do with his having a reasonable expectation of privacy in relation to his mother's criminal trial. It had to do with the impact upon him and his psychological health and well-being of what was likely to happen if and when. Of course, I've no idea whether it actually did happen, of course, but that's neither here nor there. It's just the point that it isn't only a reasonable information in respect of which there's a reasonable expectation of privacy is, of course, something that's protected by Article 8. But there are other things that are protected by Article 8 as well. And Ries is a very good illustration of that.
Absolutely, but where the issue is misuse of private information by publication, the test is laid, the threshold test is laid down in, as we understand it, in Campbell and in Murray.
That's not the issue.
And that's reasonable expectation of privacy.
Really, the point is you want to report what happened openly in court. So it's, so the very nature of the information that you're primarily concerned with is that it's not private information.
It's not?
It's not private information because it happened in public. Anyone who was sitting in court would have heard what was said.
But we failed on that in front of Mr. Justice Tugendhat. It was accepted that even though we wanted to report information that had come out in open court, it was private information. That we failed on that. But my understanding is that the threshold test in a claim, the cause of action here was misuse of private information.
Well, you've said a number of times that the threshold test is a reasonable expectation of privacy. That is a proposition that is very far from free from controversy, and it's debated among some of the members of this panel in a case called JR 38. As it happens, the debate was arbiter to the final decision, but there was a distinct difference of view as to whether or not it could properly be characterized as a threshold test, as you put it.
Well, I'm a mere media lawyer, and we work with Campbell and we work with Murray, and when we face injunctions in the High Court to prevent the newspapers publishing information on the basis that it's private information and its publication would be a misuse, the current understanding, and you'll see this in ERY, if you look at Mr. Justice Nichols' decision in October, is that there are two stages to the test, and that is the first stage to the test. Yep. I do understand the point that Lady Hale is making. Article 8 is engaged in all kinds of different situations, but I'm trying to stress the situation we're in here is not a criminal court making a publication ban. It's not a 4.2 case or an 11 case. It's another court here, civil court, making an injunction to prevent that reporting. Now, Baroness Hale will remember that when we argued Ries, an issue came up from below about the jurisdiction and the extent to which the jurisdiction was founded on wardship and the various strands of wardship in those cases. And the Judicial Committee said quite clearly, no, the jurisdiction is founded on Article 8.
That is because wardship is there to protect the wardship proceedings, rather than to protect the Article 8 rights.
Yes, but the court did say...
Anyway, this is a side issue for... That issue is a side issue.
It's an interesting issue. Whether in a case like this, an open justice case, the Campbell and Murray principles don't apply, even though the structure of the case is the same, the shape of the case is the same, an injunction and misuse of private information. But anyway, I mean, I've accepted that submission was made, didn't succeed, and the case resolved itself by reference to the balancing exercise. So we were on Ries regarding the Article 10 right and the impact on it of the postulated injunction, which is the next question. Lord Steyne advanced a number of important general propositions. The first one at paragraph 28 on page 611 over to 612 is probably the most important. I start with the general proposition. In Reynolds versus The Times, Lord Nicola Birkenhead described the position. It's through the mass media that most people today obtain their information on political matters. Without freedom of expression by the media, freedom of expression would be a hollow concept. The interest in a democratic society in ensuring a free press weighs heavily in the balance in deciding whether any curtailment of this freedom bears a reasonable relationship to the purpose of the curtailment. These observations apply with equal force to the freedom of the press to report criminal trials in progress and after verdict. In other words, the more press coverage of these matters there is, the more information the public will have available to it about the criminal justice process, and more discussion there will be about the way it's working and what the public thinks about the way it's working. That's my observation. Paragraph 29, at page 612, he drew attention via Lord Wolfe's well-known observations in the Keim-Todner case to reporting deterring inappropriate judicial behaviour and maintaining public confidence in criminal justice. It's between C and D. Now, we don't say that the protection given to the appellant through the granting and the maintenance of the Section 4.2 order in these criminal proceedings, postponing reporting of all parts of the trial in which the appellant had been or was to be referred to, was inappropriate judicial behaviour. But it might be thought, after an informed public discussion of what happened at the Central Criminal Court, that the granting and the continuation of this relief to the appellant, especially after he was de-arrested, was generous and possibly even a purported exercise of a jurisdiction which didn't actually exist on the facts. Indeed, the mere fact that an adult, unindicted suspect in a criminal investigation leading to a trial can instruct lawyers to attend the Crown Court trial on a number of occasions to postpone reporting of open parts of the trial in this way is also in itself of considerable public interest. Many people would be surprised that this is possible. If it became commonplace, if it became the norm, which it would not, because most suspects could not afford to instruct lawyers to apply for relief in that way and attend court, it would have consequences, serious consequences, for the efficient conduct of criminal trials. Because, as I've stressed, references can come out in open court to suspects in investigations in criminal proceedings in all kinds of ways, at all times. And you face the prospect of Section 4.2 applications being made repeatedly during a trial to protect the interests of those people. The making or outcome of the subsequent injunction application, assuming its failure, is also of public interest. It's part of the same story to be told, and it's in the public interest to tell it against the backdrop of the Section 4.2 proceedings at the Central Criminal Court. This is much for the same reason. There should be an informed public discussion about the sequence of challenges made by the appellant to our right contemporaneously to report the relevant aspects of the criminal proceedings. Again, many may be legitimately interested in this. How, by what means and when somebody with the resources to do so can prevent routine reporting of open court proceedings and criminal proceedings in this way for a period of 3.5 years. Some may be surprised that this can happen. To suggest that there is no public interest in what I would call the saga of the Section 4.2 proceedings and the privacy proceedings in this case, from start to finish, from magistrate's court through to the end, is, with respect, completely misconceived. There is a self-evident public interest in reporting that. I accept an issue is raised by my learned friend, which I'll come on to, about identifying PNM in the course of that reporting. But the suggestion that there isn't a strong public interest in reporting that is absolutely hopeless. And of course, with these comments, which are really submissions on my part, we overlap into Lord Steyne's observations at paragraph 30 at the bottom of 612 and over on to 613 about contemporaneous publicity, ensuring that trials are properly conducted, being a check on the criminal process, and the need for informed debate about criminal proceedings. Lastly, we rely on the observations at 32 to 36, page 613, about the implications for the media of the High Court jurisdiction to grant injunctions being used to prevent reporting of criminal proceedings. Lord Steyne expressed concern at 32 about the jurisdiction being used by adult non-parties as well. We note that he does not say at the end of that sentence the jurisdiction under the ECHR could equally be invoked by an adult non-party faced with possible damaging publicity as a result of a trial of a parent, child, or spouse. He doesn't say at the end of that sentence, or others, which is the situation here regarding the suspects who weren't charged. They're in an altogether different and further category. This could yet be, would be, if an injunction were granted in this case, yet another significant extension of the jurisdiction on the facts. I'm not saying it's impossible, but the point he's making is that the jurisdiction has the potential to fan out and cover all kinds of aspects of criminal proceedings where people will want to invoke the privacy right.
But we mustn't forget that this was all about an attempt to prohibit the identification of a defendant in a murder case.
No, absolutely. I appreciate that, and it will be said that the public interest in reporting that is different and stronger on well-recognised dicta in our courts than this. But this is still, on the submissions I've just made, an important public interest piece of reporting about what happened in this case and the way in which the reporting of the trial was postponed and then injuncted by the courts, or there was an attempt to injunct it. And also to refer in the report of that process to the aspects of the trial that are substantively an issue, the references made to him at the trial, how they came out and why they came out. Yes, at 33, at 33, Lord Steyne does say, well, another way in which it could fan out further is beyond an attempt to prevent merely attempt to prevent the identity of a defendant. You could seek to prevent all kinds of other bits of a Crown Court trial from being reported. Then at 34, he expresses concern, speaking for the court, about newspapers who cannot resist an injunction, being less likely to report the surrounding issues prominently. Those are his well-known disembodied trial comments. That's 34. It is a general public interest consideration. If the expansion of injunctions in relation to reporting of criminal proceedings makes it less worth the candle, if I can put it that way, for the press to slog through these trials and report them because they're concerned about injunction proceedings or have to fight injunction proceedings, there will be less reporting of criminal proceedings. It's a consideration that has to be taken into account. 35 and 36, the practical difficulties and costs of having to resist such injunction applications are discussed, especially if the case goes on appeal, and especially for the regional and local press, which is exactly what's happened in this case. My clients have fought this case. That's self-evident, and they've fought it at all levels. But many would not. Many newspapers would not. Lord Staines's comment at 36 about a serious criminal trial being of great interest in the community where it took place, this is on page 613, fit exactly with what Mr. Colley said in his statement about the Operation Bullfinch trial in the Oxford area and amongst the readers of the Mail. These all remain as concerns. All of the matters dealt with by Lord Steyne in that section of his judgment are concerns today as much as they were before, if not more so. We accept this case is not about a defendant being anonymised, but if the law were to prevent others referred to at a trial, especially as the uncharged suspects in the investigation being tried or that's been brought to court to be tried, the same thing is liable to happen. The report may not be published at all, or it will be published less prominently. Before I turn to the Guardian case, which was the second case relied on by the Court of Appeal, could I ask you to note, as it were, the chronology of the cases? To this extent, in 2008, the RIES approach to injunctions restricting reporting of criminal proceedings was discussed by a 5-judge Court of Appeal, including, I think, my Lord Wilson, in the Court of Appeal in a case called In Re Trinity Mirror, which is at tab 13. In 2009, the RIES approach and principles were applied by the House of Lords in a case called In Re BBC, which is at tab 5, an important case to which I will come in due course. So the approach in RIES was embedded into our law at the highest possible level over the succeeding years. The second case relied upon by the Court of Appeal was In Re Guardian at tab 7.
Before we leave to that, go to that, with your help, we have looked very carefully at RIES.
Yes.
And the question arises, what did Mr. Justice Tugendhat mean when in paragraph 80 he said, "In my judgment, I am bound by the decision in RIES"? What is your submission as to the decision in RIES by which he regarded himself as bound?
Oh, I take that to mean paragraph 17 of Lord Steyne's judgment, the parallel analysis and the jurisdictional basis for injunctions in these cases. That is High Court...
You mean the balancing
yes.
exercise?
Yes.
But there was no dispute, was there, before Mr. Justice Tugendhat, that there was a balancing exercise between the two articles of the Convention. So, if I'm right about that, it was odd for him to conclude matters by saying, I'm bound by the decision in RIES. Because, as you know, Mr. Barker submits that Mr. Justice Tugendhat there very much had in mind the comments by Lord Steyne that most people would be able fairly to distinguish between arrest and conviction.
Yes, I'm coming to in due course. I'm just focusing on the first question you asked me about.
Thank you very much.
What he meant by saying that. Mr. Barker, of course, has to some extent challenged RIES, certainly in the Court of Appeal. I didn't do the hearing before Mr. Justice Tugendhat, so I don't know to what extent there was submission about the appropriateness of following the RIES course, But what I take him to mean by that paragraph is, in the approach I must adopt to this case, notwithstanding that it's a case about a suspect who was investigated and who was arrested, it's like any other Ries-type case where an injunction is sought in the High Court to restrict press reporting of a criminal trial. I must apply the parallel analysis in paragraph 17 of Lord Staines's judgment.
In the paragraph to which Lord Wilson has just referred, Mr. Justice Tugendhat refers specifically to Ries at paragraph 32 and says that the claimant is an adult non-party to the criminal proceedings, and his position was specifically addressed in Ries at paragraph 32. When one looks at paragraph 32, it's there are observations there about the possibility of jurisdiction under the ECHR being invoked by an adult non-party, and one sees what was said.
These are the passages in Ries that Mr. Wolanski relied upon, as I rely upon them at this trial.
Yes. Well, what do you say that Mr. Justice Tugendhat was taking from paragraph 32?
I think he's just, if you go back to 64, he's simply saying Mr. Wolanski relied on the following passages. The question is, what was Lord Steyn meaning by that? And what Lord Steyn was meaning was that there are risks of damage to the Article 10 right, press reporting of criminal proceedings, a chilling effect, if you like, if the injunction jurisdiction identified in Ries becomes regularly exercised or commonplace and extends beyond these sorts of facts involving CS, so that you've got adult applicants for injunctions, you've got applicants for injunctions wanting to injunct pieces of the trial other than the identity of the defendant. Lord Steyn referred to a gruesome crime scene and so on and so forth, that the press could end up having to face these applications all the time if the jurisdiction widens.
So is Mr. Justice Tugendhat dealing with this as a category argument and rejecting the category argument on the footing of paragraph 32 of Ries?
No, not at all. I don't think so. I think what he's saying is the problem in weighing Article 10, Article 8, you can weigh in specifics. You can look at the harm to the family, you can look at the reporting, you can look at the applicant's witness statement. What Lord Steyn is saying in Ries is consistent with a whole line of Strasbourg authority and open justice authorities in this country, is that the more judges restrict freedom to report to criminal courts rather than Parliament, but the more the judges do it and intervene and exercise that jurisdiction. And here is a new jurisdiction in Ries. This is the Article 8 jurisdiction in the High Court being used to do that. The more you do it, the more potentially you chill reporting by the press of open court criminal proceedings because of the fear of being injuncted, for the fear of, I'm going to come to this later on, of being sued in damages later on, which is the implication of the appellant's case, and that is, as a matter of public interest, undesirable. It's a public interest on the Article 10 side of the balance that has to be looked at in general terms rather than the sort of specific terms that you look at the harm on the Article 8 side. I don't know if I've put that terribly well, but that, I think, is what Mr. Wolanski was arguing, and that's what I'm arguing by reference to those observations in Ries. And we say it was perfectly appropriate for Mr. Justice Tugendhat to take those considerations into account. They will be in play and manifest in any case where the Ries jurisdiction is used to try and restrict press reporting of open criminal court proceedings. The second case relied on by the Court of Appeal was In Re Guardian at tab 7. The shape of this case was different. It was not about an injunction to restrict press reporting of public criminal proceedings. It was nonetheless an open justice stroke court reporting case. It concerned orders in civil proceedings which had started in the admin court. the orders did two things. They anonymised the claimants in the admin court, and in the civil proceedings, and they prevented the press from identifying them in press reports of the civil proceedings if the press knew who they were. So in effect, the orders were injunctions against the press. So anonymised in the courtroom and injunctions preventing reporting. The proceedings concerned a combination of directions and asset freezing measures against the claimants based on a claim by the Treasury that it had a reasonable suspicion that they were or might be facilitating acts of terrorism, and they were challenging the measures against them. The press challenged the anonymity order and injunctions in the appeals to this court, to the Supreme Court, for the first time. And in the end, there was only one viable Article 8 argument for continuing the orders in the case, in one of the claimant's cases, known as M, and that failed on the facts, as we will see. And the last thing I'll do, if it meets with your approval, because we're nearly at 4 o'clock, is just take you to the facts as they're summarised at paragraph 21, because they're quite similar to this case.
Right.
Page 583.
Yeah.
Under the heading M's position at 21,
Yes.
that leaves the application by the press for the setting aside of the anonymity order in respect of M. According to a witness statement submitted on his behalf, M lives in the same property as his ex-wife and 5 children. He is involved with his children, taking them when he can to school or the park, etc. He fears that if his designation as a suspected terrorist is revealed, this may lead to a loss of contact for himself and his children with the local Muslim community, who may fear to be associated with him.
Yeah.
Furthermore, in the written submissions on his behalf, the argument is that publication of his name would cause serious damage to his reputation in circumstances in which he has not been charged with or convicted of any criminal offence, and so has no opportunity to challenge the substance of the allegations against him. In that situation, an anonymity order is said to be needed in order to protect his Article 8 Convention rights. So you can see the similarity of the issue that was before the court in The Guardian and this case. It wasn't a sex offence case, but it was reasonable grounds to suspect guilt of a very serious criminal offence, involvement in terrorism. And evidence was put before the court as to the impact of that being reported on his Article 8 rights. So that's an appropriate point, my Lord. I'll return to look at some of the observations in The Guardian tomorrow morning.
Very well. Thank you very much, Mr. Miller. We'll rise now and resume again at 10:30 tomorrow. Court's now adjourned.